Hi, and welcome to this month's edition of Up to Speed. My name is Mike.mader, the dealership industry leader for Baker Tilly US. I hope the selling season has gotten off to a good start for you, but today's Up to Speed, we're going to talk about the merger and acquisitions. So, Up to Speed is here to help you learn about topics that pertain to retail dealerships and comes to your mailbox the third Wednesday of every month. If you'd like to listen to or see some of our past episodes, you can find them at www.bakertilly.com/dealerships. Also, if you have a topic that's on your mind and would like some additional insight to it, please let us know by reaching out to us on our website. Our goal is to provide you with relevant, up to date information that is quick and easy to digest that pertains to tax, accounting, and operations of an auto dealership that you can watch or listen to on the go. The auto industry is still in a very strong merger and acquisition mode. In the most recent Hague Partners report, more dealerships have changed hands in quarter one of 2024 than any other quarter in the auto retail history. Private dealers acquired an estimated 131 dealerships, and publicly traded dealership groups acquired a total of 20 domestic auto dealerships in quarter one. If you're thinking about buying or selling your dealership, there are some things that you need to be prepared for and have in place to make the transaction go smoothly and reduce the risk of any mishaps. Today, I have Lee Lovett with me to discuss some of the legal pitfalls you should be aware of as you contemplate the sale of your dealership. Lee is an attorney with Bass Sox Mercer, which is a law firm in Florida that represents auto dealerships, truck, and motorcycle dealers throughout the country in complex commercial transactions, business and franchise disputes, operational issues, and litigation. Lee joined Bass Sox Mercer in 2022, but prior to joining the firm, he served as general counsel for one of the country's largest privately owned auto dealership groups with operations in over 40 dealerships in 8 states. Lee works in the merger and acquisition practice of Bass Sox Mercer. Welcome, Lee. Thank you for taking
Hey,
some time to speak with us today.
thanks, Michael. I appreciate you having us.
Yeah, we got a good topic today, and you're well versed in it. So let's get right into it. And I want to just ask, can you give us a little bit of a walkthrough on a transaction? What are kind of the steps in a high level?
Yeah, I can walk you through those steps, Mike. I think probably what a buyer and seller should know is that any transaction is not going to be a quick process. It's going to be kind of a long marriage between the
Mm,
parties. Any kind of deal, I mean, start to finish. I mean, you could be with each other for months on end. It's a long process, that's for sure. So it all kind of starts in the beginning whenever you're putting together the pricing and you're putting together that letter of intent on what the transaction is going to look like. That starts off with, as any deal should, with a non-disclosure agreement between the parties, where the information that's being exchanged between the buyer and seller is going to be held confidential. It allows the seller to freely share their financials. It's not a full in-depth disclosure of what the business looks at. It's mainly just some general financials between the parties and contracts, what the assets look like, any kind of real estate items, environmental due diligence items that they may have readily available, that allows a buyer to adequately price a deal. From that phase, you're going to get into what we call a letter of intent between the parties. That's usually the business people are outlining kind of the four corners of what an agreement's going to look like. You hope to get as much as you can laid out at that level and not have it as much up in the air. But at the same time, you don't want to get too detailed and in the muck with it. I mean, a good LOI is probably 3 to 4 pages. I've seen some come across my desk where it's 30 something pages, and it's a little bit harder to digest, because usually an LOI, although you probably should get your advisors involved early on in the process, the number of times that deals come to us after an LOI has been signed is, I would say, a good majority of them, more than we'd like to see.
And the
And so,
LOI is that's kind of the negotiation side of it, and that's when you're going to see, all right, this is what we're willing to offer you. Is this
yeah,
what you're willing to accept? It's kind of the start of the negotiation process.
Oh, 100%. And I mean, I would say it's a lot harder to retrade on your terms once you've signed an LOI, right?
Yeah.
It's as much as an LOI isn't, the true enforceability of it is in the exclusivity and the confidentiality provisions that are likely in an LOI. The terms that you agree to in a letter of intent, they're not going to be that enforceable. You're going to be able to go back on them, but at the same time, it's parties aren't really tolerant to renegotiating on items that
Right.
they consider done and put to bed. And so that's why we say if you're going to be entering into that LOI phase, you want to have your advisors involved at that stage so you can properly put the boundaries on your assets, properly put the pricing terms that you need in there. After your LOI is finished, that's whenever we go to work, the attorneys, and we're putting together your asset purchase agreement. I mean, vast majority of deals in this industry are asset deals versus equity deals.
Mm-hmm.
So in that, you're making your asset buckets, you're setting your pricing, you're determining what your adjustments are going to be. You're coming together on what liabilities of the seller are going to be assumed by the buyer, and walking through what your excluded assets are going to be, and kind of laying out your pre and post purchase obligations that you owe to one another. If you have real estate involved too, that's a whole separate deal. You're going to have a
Right.
real estate purchase agreement. Maybe you're drafting leases. Maybe you're assuming the lease of the seller, but that's a whole separate deal as well. And then from there, it's once the contracts are signed, you're reporting to the manufacturer, and then it's off to the races. I mean, those 30 to 60 days post signing of an APA are highly important from a seller's perspective, because you're doing a lot of document gathering. You were probably getting together a few things related to your financials early on so that the buyer could kind of put together a good price and kind of know what their outlay is going to be. But I mean, once after an APA sign, you're going to have a ton of schedules to go through. You got to get together your employee reports. You got to get together asset lists, contracts. It's a large document gathering process for those first few weeks after an APA, but then it's mostly into the buyer's hands, and then they're doing their due diligence, their manufacturer applications during that 30 to 60 day window. And then hopefully you're getting something back from the manufacturer after then. I mean, we've seen some that drag out months, but I mean, that's always the goal, is you go in a lot faster, go in prepared, and hopefully you can get that done. And then from there, once you get all your approvals, licensure with the state, manufacturer approval, that's whenever we start really ramping up for closing and try to have a successful closing. And most good closings we try to happen over about a 3-day period, and try and get it done. I mean, it's a long process that could take a few months, but that's why it's good to have people that kind of know what they're doing and going through it, because you get tripped up in a lot of different places.
Well, I'm glad you said hopefully you can get the manufacturer approval, because that seems to be, I mean, you probably know better than I do, but I think they've got 30 days to approve it after they've received all the information they think is necessary to approve the deal.
Yeah.
So
Yeah. Every state's a little different. I mean, most states will lay out how long the manufacturer can review the process, but mostly all of them will caveat it with after they've received the full application set, and they'll re-request items, and it could kick out another 15, 20 days, something like that.
yeah.
So, I mean, you can have processes go a long time. I did a deal I closed one this past week where the contract started in September, and here we were in May closing a deal. We didn't get approval until until the end of March. So, I mean,
and you know, like most dealers, they're expecting, hey, all right, we're signing this today, 30 days, we should be done. I should have my cash. That's not going to happen.
Yeah, no, it's like I said, it's a long marriage, and so you just got to know that kind of going into the process.
Yeah. So when, as you're seeing these deals happen, what are some things that you see most often that either surprise you, delay the deals, or have the deal fall out of bed at the closing table?
Yeah, I think the main thing that you want to do, if you want to take it in two different aspects, from a seller's point of view, the main things you want to do are limit the possible retrade points during a deal. And the best way to do that is limit your unknowns and limit your possible things that are going to show up during a deal that weren't negotiated at the time of the APA. Because you don't want renegotiations, you don't want something new to pop up that you didn't disclose early on. And in order to do that, that's from a seller's perspective. Going into a deal, you want to make sure your house is in order. You know what your assets look like. You know what your liabilities look like. What you should be asking yourself things like, when was the last time I did a good parts inventory? When was what does my environmental look like on my property? Is something going to show up during their due diligence period that they're going to come back and have questions and want to reprice my deal? The more you can disclose at the front end and negotiate those terms whenever you have your leverage as a seller. Your leverage as a seller is the best at the time before you've signed up the deal. Once you're in bed, you've already notified the manufacturer. Maybe your employees know that something's going on because people are investigating the property. Now there's surveyors out here. Your leverage goes down a lot in those kinds of deals. So we try and tell sellers the most that you can know, that you can nail out at the front end, the better. And that's not only in determining what your potential assets look like, it's also what your liabilities look like. And if you are going to need liabilities assumed by that buyer, think long-term contracts, DMS systems, key track machines, equipment leases, things like that. You want to know what your termination of those items looks like, or your assumption looks like early in a deal versus, I'll give you an example. We did a deal out in Texas, and they had their DMS system. It got disclosed probably later in the process than we needed it to, that they still had another 8 years left on their DMS system, and the buyout for it was going to be in the 7 figures, right? Like, that's not a good retrade point to be talking about in the middle part of a deal after everything's been negotiated, and you're either going to have to eat that or or try to take a lower amount to get the buyer to assume it. From a buyer's perspective, it's also important, I would say the big part is do your due diligence. Actually do your due diligence. Don't leave things up to the closing table on thinking I'm gonna investigate the property at some point. Yeah, sure, I'll do a walkthrough. Really go through the property and do a walkthrough. Don't walk through the service bay, count lifts and just assume everything's okay. I mean, for instance, we recently did a deal where buyer comes in on closing day and notices all the lifts are leaking. Every single one of them, all the lifts in the service center are leaking. And it's frustrating from both sides, right? Because that's something that, as a seller, I say, well, you had 90 days to look at this. Like, you should have been looking at this, and we're past your inspection period. But as a buyer, I'm expecting to buy a fully operational, good fixed assets. So those kinds of things can cause frustration at a closing table. And so I would say doing your due diligence, not leaving things to be determined. You're going to have some items that are determined at the closing table, used cars, things like that are going to have to be mutually agreed upon. But the more that you can nail out on the front end in your contracts, determine what your pricing mechanisms are going to be, get real granular on how you're determining what fits into your asset buckets, what's considered manufacturer parts, what's considered non-manufacturer parts, what's your special tool definition, what's falling into your different pricing buckets for fixed assets. And really getting granular into that saves you a lot of headache, because you don't want to be retrading the deal at the closing table, because parties will.
Yeah. So in the LOI, you want to go somewhat granular into some of those things, but do you put in the fact that how you're going to price the used inventories in the LOI, or are you going to wait until the APA is done?
I would say so. I'd say the majority of deals in the industry, used cars are probably considered just mutually agreed upon, just because there's such a variance in the market. I will have some dealers that will say, listen, I want it to be known. I want it to be sellers saying, I'm getting out of the industry. I want it to be known what I'm getting. And for that, I'm going to take MMR plus $100 at the closing table. And you may be underwater on some, you may be in the good on some, but we lay out a pricing mechanism. I'd say that's not the majority of deals. The majority of deals, maybe, especially if the seller has other operations and they're just selling one aspect of their operations, they're going to move their used cars somewhere else, or they're going to send them out to a wholesaler. They're going to have options to do it. I'd say more so what you see is related to, okay, how are we dealing with obsolete parts? How are we dealing with what's fitting into your parts definition? Because I mean, you could have a seller that hasn't done a parts inventory in 3-4 years, and they think they know what their parts inventory looks like, but then you get to the closing table and you got $100,000 in obsolescent parts, and you're trying to figure out what you're going to get for them. And if it's mutually agreed upon, someone's going to say, I'll give you 5 cents on the dollar, and you may have a little bit more leverage if you could iron that out ahead of time.
Okay. I think you see a lot less in the used inventory issue just because there is, or was, I should say, kind of the lack of supply. So anybody was going to take used car inventories no matter what they had to pay for them. Yeah. We might see that turn a little bit now that, rates are a little higher, inventories are starting to get up, move up, and the supply of inventory is getting out there now. So, but who knows? We'll wait and see how that works out throughout the rest of the year. Yeah. So seller financing, what are you seeing more of that in the market now with interest rates higher and things like that?
Yeah, I would say we've seen a significant uptick since probably, I don't know, second, third quarter of last year. We've done a large number of deals with seller financing in them. We typically seem to see them in kind of smaller markets. It's one single, maybe 2 rooftop dealerships. Right. It's going to be in a more rural space. We see it a lot actually in the power sports and implements industry for whatever reason that we do a lot more seller finance deals in that area. I think you're probably right on I think more traditional banks are obviously rates are higher, but they're also pulling back from I think the industry approvals. What we've seen more recent deals, buyers having to go to maybe their second or third lending option to kind of get blue sky loans or get rates that they're comfortable with on the real estate. So we see it a lot more than I would say in the past, and that comes with its own issues, and that's one of the reasons why I would say you want to talk with your attorneys and accountants ahead of time before putting that into an LOI, because maybe whenever you're talking with a broker, it sounds nice. Okay, well, I'll get this certain percentage interest return. That'll be fine. I'll agree to hold $2 million, $3 million in a note, and we'll move on if we can get the deal done, if I get my blue sky. But then whenever they talk to me or they'll talk to their accountant, you start to realize the risk you're taking on by doing that. And whenever, especially if the seller financing doesn't have real estate involved with it too, because realistically, then what's your collateral? And whenever you start having conversations with clients regarding that, or what the tax treatment's going to be, and how it kind of affects their future planning and their retirement planning, I think that's whenever they really start taking it more seriously. And you would like to see that done ahead of time at
absolutely
the LOI phase. Then once we're into an agreement and I'm drafting up promissory notes.
Yeah, and I think your earlier comment on preparing, getting your books and everything lined up in advance. We find so often that all of a sudden we get a call and say, hey, we got an LOI and we need to get the fixed asset details to the potential buyers, and we're like, well, hold on, you never gave us. We've asked for updates the last 2 years to get some of these off the books. We need to clean this up before you get it done. But the seller finance, yeah, I would agree. That's kind of, you can't finance a seller's not going to typically finance a 20 dealership group. So that's your 1 and 2 off transactions that are going to 1 or 2 rooftop deals that you're going to see the seller financing on. So One of the things that we are seeing a little bit more on, I'll pretty much say it out there, it's Mercedes with OEM approvals, because the manufacturer's got to approve all these deals.
Right.
And you talked to it earlier on, when you get the asset purchase agreement signed, you got to go through that manufacturer approval process. Mercedes-Benz seems to be, if you haven't been a Mercedes-Benz dealer before, you're not getting a Mercedes-Benz deal now.
Yeah.
And are you seeing that with other franchises at all, or are there things that a dealer that's looking to buy another franchise needs to be aware of, or needs to do in order to hopefully be successful with acquiring that different franchise?
Yeah, I would say you're right in Mercedes in that regard. We have seen that, to where if you don't have a Mercedes deal, it's kind of hard to get it. It's kind of
Yeah.
hard to get a new one in that regard. I would say the other tough approval manufacturers that we've been seeing recently. I mean, Toyota, Hyundai, their approval process has been a little bit onerous coming through, and I mean, you have to deal with, in states where ROFRs are an issue, it's certainly a consideration that you have to deal with and going through the process. I mean, that's kind of where, in the run up to your deal, and when a buyer's considering a deal, that's whenever they're talking with their counsel and saying, okay, what's my potential risk here? What's the state look like with their OEM approval process? Are right of first refusals going to be an issue? What are my rights in that regard? And I think that's a big key component that they need to consider whenever they're going through a new deal.
And there's no way to guarantee that. I mean, you're trusting. I mean, I had a deal, I want to say it was probably about 4 or 5 years ago. I mean, it was a larger dealer group that was buying a single
Mhm.
point store. And we think, hey, all right, this is going to be a no-brainer. They're going to get approved from the manufacturer. Sure enough, they couldn't get approved because
No,
one of their other stores wasn't meeting the metrics that manufacturer thought they should be meeting. So they wouldn't allow the deal to go through.
yeah, no, we've seen that numerous times. Be it in a ROFR situation where maybe maybe a manufacturer saying, we don't want this public coming in here, or we think this dealer group's getting a little bit too big, so we don't want them adding another store in this market. And to the extent the states allow that, it's really hard to push back. And in those scenarios, what you want to do is make sure that you know what your rights are regarding compensation that you're going to be able to get back, and and what the timing is on that. I mean, there's some states like Oregon where if they're going to exercise a ROFR, they got to pay the other buyer out before they could actually exercise the ROFR. So as a buyer, you could actually hold up a deal if you're if until you get paid. And that's why we say, hey, if you know you're going into a state where a ROFR is an issue, make sure you're keeping track of your expenses. I mean, you're going to get a reimbursement if it does happen, but you need to be prepared to substantiate costs. And so that's one due diligence item on the front end that you can know going into it.
Okay, that's good to know.
Yeah.
So as far as you had mentioned earlier, bring your consultants, your advisors in early. So you're talking the accountants, the attorneys, and your financing side, your lenders.
Yep.
So what aspect, is there anything unique in the lender side, on, I guess I'm going to say on the legal side with the lenders, that dealers need to kind of be aware of before they enter into a transaction?
So a lot of it is going to be kind of dependent upon what type of financing you're looking for. Are you looking for strictly real estate? Are you looking for blue sky capital loans? Is it traditional financing? Are you going through an SBA process? There's all kinds of things to consider whenever you're going through an SBA lender, that you want to consider on the front end when you're negotiating deal terms, because SBA, it could be, you got to jump through a lot more hoops to get it done. So you want to negotiate yourself an extended due diligence period. So if you're trying to get SBA financing with a 30-day financing contingency on approval, it's probably not going to work. So those are the types of things that you want to be considering on the front end, especially if you're saying, okay, what kind of appraisals am I going to need to get ordered? You want to get your banks involved early, and especially knowing if you're gonna need to if you're going to need to finance the blue sky as well, they're going to need to see those financials early on to know what they're going to approve you for. So that's why I say if you're on the buy side, talk to your accountants, talk to your lawyers, talk to your banks whenever you're considering a deal. Don't slap an agreement in front of them and say, "Hey, I've signed up for this. You think I can get approval in 30 days?"
That happens more often than you think.
Oh no, I thought that the bankers will tell me. They'll say, "Lee, when did you know about this deal?"
Oh, 10 minutes before you found out.
Exactly. Just found out about it. So.
Yeah. So, well, awesome. Is there anything else that dealers should know, and as far as the buy sell side on a legal aspect that you can think of?
I mean, I think we hit a lot of the points. I would just say, no matter where you're at in the process, the earlier your people can be involved, the more disclosure to your consultants the better in those regards. As an attorney, I don't like to be surprised. I don't like to be surprised whenever stuff comes up. So early on in the process, I mean, lay it out. Let us know what your environmental looks like. Let us know if there's going to be title issues that we got to work through. And on the buy side, if hey, is there going to be manufacturer approval issues? Are we going to have to kind of jump through some hoops with your application to get us through these OEMs and with your lenders? Let us know those things ahead of time, and that way we can work it into the agreements, work into your timing, and get this thing closed. Everybody wants to close fast, right? And so that requires everybody kind of working together.
All right, perfect. So that concludes this month's episode of Up to Speed. Lee, I thank you for giving us some insights on things to be aware of on the legal side and talking about what's happening out there right now. So very much appreciate your time that you spent today to go through this with us.
Yeah, I appreciate it, Mike. Thanks for having me on.
Okay. And to our audience, thank you for joining us today. If you have any questions for Lee, his contact information will display on the screen after the session. Feel free to reach out to him directly. So we look forward to seeing you on our next Up to Speed episode. And remember, we're in your mailbox the third Wednesday of every month. But you can also go to our website, look at past episodes at www.bakertilly.com/dealerships to watch any episodes that we have out there. So have a great day and make it a great one.